I'd like to call this public forum meeting to order at 5:30 PM. Are there any declarations of interest? Seeing none, public forum applicant presentation, invoice for services respecting bylaw compliance, 83 Pine Street North. I'll call on Peter Janowski, owner and senior paralegal, Glen Lake Paralegal, agent for the owners of 83 Pine Street North, David Mancini and Tony Mancini, for his presentation respecting invoice for services respecting bylaw compliance, 83 Pine Street North. Please note you'll have up to 10 minutes for your presentation. I'll also remind you that we are in open session and information of personal matter about individuals who may be identified shall not be disclosed, so please be aware of this. You may proceed, and welcome, Peter.
Thank you, Mayor. Thank you, Council, for this opportunity to speak. As you mentioned, I am here on behalf of the property owner of 83 Pine Street, Mr. David Mancini. Here in regards, partially because as a paralegal, I've been practicing before the Landlord and Tenant Board for 12 years. And this property where this order and fines were issued was a tenanted property. First, I do want to acknowledge that there was an issue with the property, which had a long-term, which was a long-term single-family home being rented well below market value at $1,000 per month. Unfortunately, the issue was one that was not created by the property owner, nor was the remedy fully in control of the property owner. The issue did need correction, and the landlord exercised all their legal rights and obligations as far as the law allowed him to do so. The frustration, and the reason I'm here today, is the process by which the City of Thorold took to enforce the bylaw, a process that is inherently unfair and punitive to landlords, especially those who provide single-family homes as rentals, as well as tenants who most often would be from equity-seeking groups. So, with regard to the municipal order, an order was issued for the cleanup of the yard under bylaw 146-2009, bylaw respecting litter, yard waste, and maintenance of property. The order required that domestic waste was removed and the grass was cut. The municipal order was issued on July 2nd, 2024, and it was given to the property owner via registered mail, which was sent to what I presume was the property owner's previous solicitor on file. The bylaw in of itself states that the order is deemed served 5 days after it was served, which would put us into July 7th at that point. The order gave the property owner until July 10th to complete the cleanup, essentially giving them 3 days to comply with the bylaw. The problem is that the landlord, the property owner, can't just enter onto a tenanted property and start throwing things out. It's not his property. The law doesn't allow him to do that. The municipality can enter that, but had the landlord done that, and I've been on both sides of these applications at the Landlord and Tenant Board, the tenant simply brings an application, tallies the quantum, the value of what was thrown out, and goes after the landlord for all of it. And I can assure you, and I say this with only partial jest, that when situations like this happen, the landlord ends up throwing up a Picasso, a couple of Rolexes, and several bars of gold. Okay? The landlord simply cannot go onto a property that is rented to a tenant that is protected by the Residential Tenancies Act and start throwing things out, regardless if it's inside or outside. The proper process for the landlord, property owner, is to follow the Landlord and Tenant Board guidelines, forms, and procedures. Simply put, the time frame that the order gave for the property owner is not a reasonable amount of time to clean up the property, nor does it allow a property owner to even comply with that order and the RTA at the same time. The proper process requires an N5. An N5 is a notice to a tenant to do something or to stop something. In this case, it would have been to clean up the property and not to continue the behavior that led to the order being issued in the first place. An N5 gives a tenant 7 days to correct the issue. The landlord can do nothing in those 7 days. Only on the 8th day, if the issue hasn't been corrected, can the landlord file for a hearing. A hearing is scheduled right now 3 to 6 months out. When you get to a hearing, the landlord must prove that the issue is an issue, that it is somehow a breach of the landlord's rights, or that somehow breaches the tenancy or the RTA, and what the required remedy is, and if it's serious enough, seeking eviction. The order does not allow the landlord to do that. There was no pictures attached, there was no description, there was no explanation what was to be thrown out. I read the bylaw about what's defined as waste. Pretty much anything. I'm willing to bet most of you are in breach of that bylaw, having things in your driveway. A non-functioning lawnmower is considered waste. The purpose is to seek compliance. The landlord did everything that they could. They spoke with the tenants. They advised them that the city's going to come after them. The tenant did make some effort. They did clean up a little bit, but it wasn't sufficient. They continued to collect these materials. The landlord can only do so much. I was hired, we negotiated with the tenant, and only after the landlord paid the tenant considerable funds did the tenant agree to finally terminate the tenancy and allow the landlord onto the property. Prior to that, the landlord threatened violence, or the tenant, pardon me, threatened violence against the landlord, threatened police action, and threatened litigation. I can tell you from experience, if a landlord and tenant dispute rises to the occasion where the police are called, the Niagara Regional Police arrive, listen, and then they proceed to tell both parties this is a landlord and tenant board issue. You must file an application before the board, and then the police strongly recommend that the landlord leave. And if the landlord fails to leave or tries to push past the tenant to get onto the property, it is the landlord, the property owner, who is arrested, charged for mischief, obstruction, or possibly trespassing, ironically enough, on their own property. This property owner did not want to make this into a criminal matter. They did everything they could within their lawful rights to comply, to remove these possessions or these objects, or to get the tenant themselves to do it. The bylaw allows for an inspection to come onto the property for a municipal official to come on to see if compliance has been met or if steps are being made to meet compliance. No such steps were taken in this case. The bylaw officer issued the order. It was deemed served 3 days before, and then they went straight to enforcement. As I mentioned, the order lacks any details and would not have been supported in landlord-tenant board. I can also advise you that if an invoice like that was part of a civil proceeding for an unpaid invoice in small claims court or superior court, no court would award a judgment on that invoice. There's just simply no explanation of what was being charged. I'd also like to point out that the landlord was also charged under the administrative penalty system. The order was issued on July 2nd. On July 7th, a penalty notice was issued for the cleanliness. And on the day of the order being issued, the bylaw officer issued a fine of $300 for the grass not being cut, even though the order was issued the same day. As I mentioned, the property owner made extended efforts to try to deal with the situation. They offered the tenant money. They offered the tenant assistance, none of which was taken upon by the tenant. Although they did make repeated threats, to myself included, about trespassing and what's going to happen if we return to remove the items. And if I can turn your attention to the invoice that was issued. It's called a bill on the City of Thorold bill. There's nothing itemized on it. There's a $9,800 charge for cleanup. I ask you to consider, which among you would pay a $9,800 invoice that doesn't explain what it's for? There's an HST number. There's no breakdown of costs. If a business was to submit this invoice to the CRA for a deduction, the CRA would laugh in your face. What are you deducting? There's no amounts. I mean, there's an amount, but there's nothing to justify it. Is there HST on that? Is there no HST? This was for cleanup of a property, but the city's private contractor billed $10,000. The demolition of this property would have cost less to have the building removed, demolished, and all the debris removed. The direct costs are not explained. There's no breakdown on how the costs were determined. Was it hourly? Was it flat rate for labor? Was there equipment charge? And if so, how much and for what equipment? What about dump fees? Were they even incurred? Having spoken with the tenant, their position is that there should have been absolutely no dump fees incurred. Most of the materials, to his position, were scrap metal or used equipment, which would have been sold off as scrap. The wood and other organic materials are deposited for free at the municipal dump. So did the contractor even incur any costs for the removal, or did they actually get paid for the scrap metals and so forth that they brought to scrap yards?
Peter, I'll ask you to wrap up. We got less than a minute.
Okay. The landlord has to abide by, or the property owner has to abide by the Residential Tenancies Act and the human rights legislation. I suggest to this council that the city should also abide by those laws. The landlord can't absolve themselves of them, and nor can the municipality. The process here failed the property owner, failed the tenant, and I would suggest failed the residents of Thorold. It is utterly unfair for the municipality to hold property owners to a higher standard than the city holds itself when it comes to abiding by tenants' legitimate Residential Tenancy Act rights and human rights legislation. A process needs to be addressed in place to address the city's bylaw enforcement and legal reality and limitations owners face as landlords. This is going to happen more often. The issue with the tenant was mental health. It was a hoarding issue. And often, when landlords take tenants to the board doesn't allow an eviction. It requires that the landlord provide a social worker, an opportunity for correction. The city didn't provide that here. As a result, unfortunately, a family of 6 who were living in very affordable housing, who the mother suffered from mental health issues, there was disabled children, lost their housing. Because there was no way for the landlord the city provided no assistance for the landlord to bring the matter to the landlord and tenant board and have the landlord and tenant board explain to the tenant that they must abide by this or lose their tenancy. The property owner respectfully requests that this invoice is absorbed by the municipality.
Thank you, Peter.
Just one last thing. The burden is, or the prejudice is much greater on a single homeowner to pay a $10,000 bill that is unjustified, unaccounted for, than for a municipality that has an operating budget of $40 million. Okay? I suggest this is used as a learning opportunity to improve the systems, develop a process that takes into account tenants, the reality of tenants, and that moving forward, all parties can work together for a mutual resolution. Thank you.
Thank you, Peter. And now I'll call on staff response. Danny Vukovic, Manager of Bylaw Enforcement, to provide any information on behalf of staff. Danny?
Thank you, Mr. Mayor. I'll start off by saying that this file was opened following a complaint we received on June 30th, 2024 regarding a significant property neglect. The issues reported include overgrown vegetation, scattered garbage and debris, and general disrepair. There were also some concerns raised about aggressive behavior from the occupants on site. On July 2nd, bylaw officer attended the property to conduct an inspection. The conditions observed confirmed the complaint, which were grass and weeds, well beyond permitted height, and there was a visible buildup of domestic waste around the yard. A formal work order was issued and posted on site that same day. The next day, on July 3rd, that work order was also sent to the registered owner by mail using the required registered delivery method. Canada Post confirmed receipt on July 4th, which satisfies our legal notification obligations. The owner was given a compliance deadline of July 10th, 2024 to bring the property back into an acceptable condition. Unfortunately, no corrective action was taken by the deadline or in the weeks that followed. On July 26th, it's important to note 22 days after the order was officially received by the owner, contractors were deployed by the city to carry out the full cleanup. It's also important to note that during this time, the officer in charge did not receive any correspondence from the property owner or request for accommodation, which would have been acknowledged by the officer. During that cleanup, the officer had direct interaction with both tenants. The female tenant was cooperative, acknowledged she had not been told about the order by the property owner, and was given the chance to remove any personal items. She also indicated that most of the remaining materials were garbage. The male tenant later arrived and was more confrontational with the officer. Despite initial aggression, he was also allowed to remove any items he wished to keep. I'd like to add the cleanup was conducted professionally and in accordance with our bylaw enforcement policies. Associated charges reflect labor, materials, and equipment required to properly and safely restore the property. This is in accordance with our agreement with the authorized contractor. The property owner had nearly 3 weeks to respond, ask questions, take action, however, did not. That concludes my review.
Thank you so much, Danny. And now I'll open the floor to questions from council. Go ahead, Councilor D'Angelo.
Thank you, Mr. Mayor. Am I just missing it, but do we have a copy of the invoice and the pictures of the property?
I'll ask our clerk or Danny.
Through you, Mr. Mayor, I do have access to the itemized invoice identifying the labor, materials used, and everything that comes with that disposal.
Respectfully, Mayor, that's not the invoice that the landlord or the property owner received, and I did email a copy of it to the clerk.
Continue.
Yeah, I don't see any invoice here. I don't see any pictures. Like, it would be helpful if council has that information prior to the meeting.
Ask Danny.
Is there any, okay, through you, Mr. Mayor, is there any reason that couldn't have been provided this evening?
I do have some pictures on file. Nicholas, I'm not sure if you're able to share any of those in the email I provided.
Yes, I can bring up the pictures. 1 second.
If I could just speak while that's happening, Mr. Mayor, like it's hard, I'm caught in the middle now, because I haven't seen either invoice of what came from our cleanup people, itemizing stuff, and I haven't seen the invoice that was issued to the individual. So I don't know what is accurate and what's not accurate.
Going to show you some pictures now.
Okay, but does he also have, through Mr. Mayor, a copy of the invoice that was issued to the gentleman speaking, or to the, not, to the owner of the property?
Through you, Mr. Mayor, the invoice that's issued to the property owner is slightly different than the itemized invoice, but the itemized invoice can be provided for review.
Through you, Mr. Mayor, perhaps Mr. Vukovic, if you can email me the invoice.
I can.
And Mr. Mayor, just another question.
The pictures are coming
I
up.
know, well,
Nope. Sorry, I gotta go through this. Through you, Mr. Mayor, there were 5 photos that I currently have access to.
those are the 5 photos on file here.
Through you, Mr. Mayor, does that accurately reflect what was removed from the property?
Through you, Mr. Mayor, yes, it does. There was some additional pictures which were not provided, but that is the scope of what's been removed.
Because, again, I'm not an expert in disposing of garbage, but it doesn't look like there's $10,000 there. So an itemized bill would be quite helpful for the individual speaking this evening. And then the other thing I wanted to ask, regards to that, when did we implement, I believe it's a $5,000 rule that
I
you,
think it was 10,000, but
is it 10,000?
yes.
Through you, Mr. Mayor, yes, the threshold was $10,000 to provide a quote.
Okay. Do you have any further questions, Councillor Dion?
Well, I'm just trying to look at the bill, so give me a minute here because I didn't have this in advance of the meeting. I'm trying to see, is there, as I'm going through there, was there any compensation given for scrap metal of any value? Because I know in previous, we've always identified scrap value as a separate item and reduced the amount of cost. And plus this bill is $10,893.20. Should the owner not have been notified?
Through you, Mr. Mayor, during the initial inspection, the officer observed significant vegetation overgrowth and several layers of domestic waste. Therefore, at the time of the initial inspection, they did not deem the quote to be warranted.
Well, if that's the case, we're gonna have to do something about this quoting because again, here's a $10,000 bill causing angst. Someone's trying to come here and get the city to cover this. You know, the bill's been paid for in terms of, even if we reimburse funds here, it is gonna be paid through by the city. And again, part of our policy, we had gone through this quite several times, and our councillors were quite upset at the time that we wanted a quoting system for anything exorbitant. Again, this one reached that threshold and we didn't do anything about it. So there's a breakdown in process here and we need to improve that. So once the rest of council speaks, I might be putting a motion forward that can carry to council so that we could address how we're going to deal with these expenditures, because this problem is going to grow. It's not going to go backwards. There's a lot of mental health issues out there, unfortunately, and there's issues where there's properties that are being hoarded, and there's a lot of debris on those. So every time we deal with this, we have to come up with a better process to make sure that everyone's aboard. And I also want to touch upon, and I don't think it's the appropriate place here, but if an owner can't get on the property within that 3 days to do that cleanup, there has to be a mechanism that he would work with the land tribunal board or the
RTA.
Yeah, the landlord-tenant board, so that this can be worked out, so that the problem can be solved at the least cost for everyone, so no one loses tenancy, and the landlord doesn't have to pay an exorbitant amount if this can be addressed. So I think that needs to be addressed, but it's not.
That's a different
Yep.
policy item.
Yep.
Okay. Councillor Detovitis.
Yeah, hello. Thank you for coming in tonight. So you had 3 days to clean up the mess.
Yes.
I've been involved with properties like this. I think this is just, we have to do a better job with our policy and our timelines, and we have to help our staff to put those in places, because this is gonna come up more and more. And you gotta be realistic on some timelines. It's almost impossible to do that. And going on a person's property, bylaw can do that, but me as a landlord, I'll get an argument or end up in jail. So it's a touchy situation. I addressed,
Councillor Detovitis, I think
yeah,
that,
but Dan, I want
this
to,
was weeks. It wasn't 3 days before they cleaned up
but
the
there
problem.
needs to be proper timeline. Like Danny, I want to help bylaw, but I think we need to have more tools at your to create a policy in place. And like mental illness, I brought it up before, and Councilor Delange brought it today. These are touchy topics who need professionalism and more than an average bylaw can bring in. You might have to bring in EMS. You have to bring something to that table to help them and explain it to them, because we'll run into these issues over and over again unless we address the problem and come up with a detailed policy, because the landlord, it's impossible to clean up at that day. And even 4 days, even a month, it's impossible. So we have to work together, communicate with each other, find something with your leadership and to resolve this, because we'll be here all the time.
Thank you, Counselor. Counselor DeRose and then Counselor Sentence.
Yeah, through Mr. Mayor, just a question to Danny, how long did this take to clean up the yard? Like how many hours, days, whatever? Thank you.
Through you, Mr. Mayor, I believe it was 4 hours billed for officer time.
Was that for cleanup or officer time?
Yeah.
Wait. I think
The
you want
officer
to know
time would be,
cleanup.
I meant for the cleanup.
yeah, through you, Mr. Mayor, the cleanup did take 4 hours.
Hours?
Yes.
Okay, it's kind of, I'd be pretty upset if I got a bill like that for 4 hours of work. Thank you.
Counselor Sentence.
Thank you, Mr. Mayor. Through you, there's a couple things here. I mean, the pricing, we've all been concerned about over the years and getting a competitive company to come in and do it. But through you, so to Peter, thank you for coming. You can't, what does the city do if they had 22 days to do this? Registered mail went out. We have a system in place. Registered mail went out 22 days to do it. I'm not talking about the price right now. Are we supposed to wait as a city when there's a problem yard for months or years until the landlord, tenants figure things out? We can't do that. You understand? We cannot do that. So we have to act within our timelines to clean up yards, or the city will be a mess. Nobody will ever get cleaned up. You understand that, right?
Yes, and what I would suggest that is that the city works with the property owner. The landlord and tenant board is an expedited process. Had those pictures been involved, that's the first I'm seeing of them. The property owner still hasn't seen them. That itemized invoice, first we've seen it. We've never seen that, it wasn't provided. Had the city provided the order for cleanup with a reasonable time frame, with the pictures associated with it, the landlord can take that and use that as part of the application. A landlord, and we have done this in the past, where we went and unilaterally cleaned stuff up. But the landlord needs to be 100% secure and have the evidence and the backing of the municipality that when the tenant comes and then files an application saying they threw out their Gucci bags that they were holding in garbage bags behind the garage, that the city provided impartial photographic evidence, not 4 photos. 5 photos does not denote $10,000 worth of cleanup. The city needs to
Price
work.
aside, yes.
Yeah.
I understand the price aside,
So-
but
And then I would just like, the bylaw officer, Mr. Vukovic, said that when the enforcement officer arrived, he stated that the tenant wasn't aware of it. I was dealing with this. I can assure you that the tenant was very much aware of it.
But
And
you can see our problem,
Right,
right?
but a
He said,
solution-
she said,
But a solution, respectfully, would be not to send it by registered mail to an old address to a lawyer, which I'm not sure if council's aware. Registered mail doesn't get delivered to you anymore. Since COVID, Canada Post doesn't deliver registered mail. They deliver a Post-it note that requires the person who's intended to go drive to Canada Post and pick it up.
yeah, I'm aware.
So if it was posted on the door, which I'm surprised it wasn't, then there's no debate whether the tenant would be aware of it. Right? And it wasn't in this case. So there was no reach out. There was no follow-up from the municipality afterwards. They say, okay, as the officer said, well, we met a legal due diligence once it was signed for. Respectfully, that wouldn't stand up in court. You
So-
have to take reasonable steps to mitigate your losses and mitigate your damages. And that includes finding a contractor. And again, I know we're talking about price, but we have to find a contractor. And I was looking at those prices. $6,000 for dumpsters?
Yeah, that aside, I understand that. We all have a problem with that. I understand that. But for me, I do trust our bylaw. I think they do a good job. And I think 22 days, again, beyond price, 22 days to get cleaned up. What are we supposed to do beyond a city? That's 3 weeks to clean
So
up.
the city has to protect itself from liability, correct? It
Correct.
has to be, once a
Correct.
complaint is put in place,
Right.
it has to show it's doing something.
Right.
So if it starts working with the landlord, with helping them, providing them the evidence that they can use to show the tenant that the city's coming in, possibly work with Niagara Regional Health. Toronto, for example, provides hoarding counseling to tenants. Nothing like that exists in this community in Niagara. I've been trying for years to get help for these people, and it doesn't exist. If the landlord can show, just like the city can show that they took steps, that they mitigated, they are protected from legal liability. And then the party can go, look, 2 weeks, we've been dealing with the tenant, we've given you notice, we've given you the municipal order, we've given you the pictures from the tenant, we've explained everything, and there's still no correspondence, no help, no movement by the tenant. Then the landlord can unilaterally move, because the landlord can take steps if their lawful rights and legal obligations are being affected by the tenant. But the problem is property owners have tenants against them, and frankly, have the municipalities against them. So they're stuck between a rock and a hard place. Nobody's working with them. The police, I know they're busy, but they take the path of least resistance. They do not assist landlords, ever. So what is the property owner supposed to do? In this case, literally, he had to choose between threats of violence and litigation from the tenant, or an unexplained phantom cost that's conjured out of thin air after the fact. Usually, from my experience with other municipalities in Niagara region, the order includes, by the way, here's the cost for cutting your grass, $456. If you didn't buy it, you're getting stuck with this.
Right.
Here is our hourly rate for our staff to come and clean up the yard, $60 an hour per employee, plus, so it's itemized in advance, so the landlord can go, you know, this is a big risk, and then they can take that to the landlord and tenant board.
Okay, I'm good, thank you. I don't think it was conjured, but I understand what you're saying. Thank you.
And I want to clear something. I think that Danny mentioned in his remarks that it was posted on the door as well as sent by registered mail. Am I correct?
Through you, Mr. Mayor, you are correct.
So
And
it was posted, just so that's clear for everyone, it was posted and sent by registered mail, okay? So the tenant knew because it was posted on the property. Okay, Councillor Longo.
Thank you, Mr. Mayor. Through you to the opponent's agent. Sir, you mentioned a few dates at the beginning, early July, 2nd.
Yes.
It was sent out, it was received on the 7th, I guess?
No, it was, and it was sent out on the 2nd. Mr. Vukovic said that it was signed for on the 4th.
Okay.
The bylaw states that when it's sent,
Sir, when did your client receive it?
I'm not sure my client received it until well after the fact, because it was sent to a lawyer.
Okay.
I'm not sure what the correspondence was between them at that point.
So they had no idea between the 2nd of July and July 26th that anything was up?
No, they did. They actively worked with the tenant. They tried to convince him. They tried to get him to
So
do it.
enough time was given, plenty of time.
Plenty of time.
That's enough. I'm just asking some questions here. You said you're surprised at the photos. Did your client not go and stand on the sidewalk and look into the yard? Did they not have an idea that it was a disaster and that neighboring properties had to put up with this?
No, of course they were aware of it. My position was that many other municipalities, when they issue orders, or even our photo radars, all include photo evidence.
Okay.
So there's something to support that the landlord can go to the landlord and tenant board
Yep.
and say, here are the impartial third-party municipal evidence of
And
the issue.
Sir, my next question is, is your client's property, is it licensed by the city of Thorold as a rental unit?
Yes,
It is, okay. And
Yes.
there's a garbage plan?
it's licensed, so it met the criteria. It's
And they met the
municipal
criteria and
pickup.
had a garbage plan in place? Because that's part of the criteria.
Well, the garbage plan is,
Is removing garbage and recycling material and
it's
so
a
on.
single-family home. The region comes, picks up the garbage, which is a
Okay.
point that I'd like to quickly make. The order didn't even allow the tenant.
Sir, I've asked my question, thanks.
Okay, so the garbage plan.
Sir,
No, wait. Do you have more questions?
I have a question for our staff member.
Okay, go
Okay,
ahead.
yeah. I just want my questions answered.
No.
We could be here till 9 o'clock
Yeah,
tonight.
yeah, go ahead.
Thank you. Through you to the manager of bylaw enforcement. I'm losing my train of thought here. The residential bylaw for licensing, does it require a garbage plan to be in place?
it does require, through you, Mayor, it does require a garbage plan to be in place, as well as for the owner to ensure the property is maintained at all times.
Yeah, okay, that's what I thought. Thank you for that answer. Thank you, Mr. Mayor.
Okay, Councillor O'Hare.
Thank you, Mr. Mayor. Through you to Danny. Danny, we've seen in the past, and I think we all decided as a council that it was really important to put these notices on the door. I've seen some recently where it notifies the tenants of a bylaw infraction and a possible order. Does that include itemizing items that are creating the problem?
Through you, Mayor, to the councillor, that does not. However, the officers do send out a photocopy of the bylaw with the definitions of domestic waste.
And not only the definitions, but with specific items on that property, like we could see it looked like a swimming pool in the back, tires, a broken fence. Are those items listed as well, so they know very clearly what needs to go?
Through you, Mayor, they are not listed. However, either the tenant or the owner generally reaches out to the officer for clarification. In this specific case, I'd like to add this property has been known to us for at least 4 times. Each time the owner has never reached out, and after the delivery of this recent notice, the owner has never reached out to us to make any accommodations. Otherwise, we would have absolutely accommodated.
Mm. Maybe this is something we should discuss if we take this further and try to figure out how we can tighten up this system, is to itemize right from the beginning, so there's no question what is being discussed with the tenants or the landlords. So that's all.
Thank you.
Thank you.
Anyone else? There's no further questions, so I want to thank Peter for your presentation.
Thank you, council.
Go ahead, Councillor D'Angelo.
Thank you, Mr. Mayor. I think it's important that we look at this as a learning process and see how we can, as Councillor O'Hare, sorry, my apologies, would, as he mentioned, and I also spoke of it, that we need to tighten the practice a little bit so that everyone's fully understands it. I think that the individual receiving the bill should have an itemized bill. I can't see why they wouldn't get an itemized bill. Even if it's the bill that's received, this should be a pass-through where it doesn't cost the city anything. So if we're getting a bill from our contractor, then it should then be put right, that bill can be sent right to the individual, and if there's administrative cost, to add that on top of it. So I think that's important. And the other one is working with in respect to the Landlord-Tenant Act also, because we can't, if there's an expectation that the landlord could go there and clean it up, or even take pictures on the property, if he's not allowed on the property by the tenant, there's no way he could take pictures. I guess he could go around and take pictures from the side properties, but that wouldn't be appropriate. So I think there has to be some mechanism there. I know the timeline, and it went from the July 2nd to the 22nd, or 26th, so there was some time there to deal with this. But I think it became maybe a bit of a communication breakdown at that point in time. So I think there's an area for improvement here. And also a suggestion is, if we're not going to give a cost estimate below $10,000, we should be able to give them a cost estimate on what the services that could be expected, such as $60 an hour for cleanup, $300 for a bin, whatever it is. That could be given both to the owner of the property and to the tenant, so they can do some calculations themselves, just in case this creeps over, is under the $10,000. So
Okay, so those things are, well, I understand the point you're making, and you want to change the policy.
Yeah.
So bring a notice of motion to review the policy, but we're working under the existing policy for this case.
Yeah.
And I'm not saying those aren't good suggestions, but that would mean then that under notice of motion, you can bring a motion and we can try and tighten up or get a more wholesome policy in place, but we're working with the existing policy. Go ahead, Danny.
Through you, Mr. Mayor, I do want to mention one thing. The officers have, in the past 6 months or so, have been sending quotes with every Clean Yards order. It has been proven effective, and we are doing it now with every single Clean Yards order.
Okay.
That would have been nice to know in a report with information coming before us. These are the things that, we're part-time counselors. We're not here every day. When I come here, I expect more than a verbal report on an issue like this. I would expect pictures, I would expect an invoice, I would expect a report. And there's some great things you can add in there to educate me as a counselor, because I wasn't aware of that. I bet you no other counselor was aware of that, right? So this is communication, both from staff to council, council to staff, and to the general public, and to those that are being affected by the bylaws. I think this is an area that we could all improve on, and I think, again, and to bring a notice of motion, can I not just give staff direction here? And if it's supported by council, moves to council, moves forward, or I have to go through the process of notice of motion? Like, we're trying to improve our city, but.
Okay, well,
we
wait.
put a
Let
lot of
the
red tape.
clerk please speak.
I know, but I'm still
I
on the floor.
understand, you
and
said, what can we do? So I'm getting you an answer,
Okay, but you
okay?
cut me off halfway
You
through my
don't have to
sentence.
keep going on. You asked the question, we'll get you an answer
I'm
for
doing
that.
my job.
So this is the, through you, Mr. Mayor, this is a public forum committee meeting. I fully realize that every member of council is on the committee. However, you're not technically meeting in your capacity as council
Council,
currently.
that's right.
And it's council that provides direction to staff through motions. So that's why what typically was done is it would be a motion to refer to council, and then council would make their decision at that point.
So he can make a motion to refer it as direction to staff, but it would be done in the council meeting, am I correct?
Yes, in the PFCs, the public forum meetings that we've had in the past, what's happened is it's a motion to refer to council, then it gets added as an agenda item to the council meeting.
Okay, so if you want to do that,
I'm fully aware, that's what I was proposing, because we do this with all our other committees. They make recommendations, they go in front of council. I know this is not a council meeting. That's what instead of doing a notice of motion, where then I have to speak on that, and then it's another 2 weeks, like, this is where red tape kills us sometimes, so I'm trying to follow the process we have in place. Thankfully, you've explained it the way that I understand it, and I'd like to put that motion on the floor that we revisit how, I'm not a wordsmith here, so.
he'll work on that. You're asking that we refer the policy to staff to come back with a wholesome report, but he'll massage that for the council meeting.
Exactly, and I appreciate the positive comments that our staff have made,
Yeah.
and how they could massage that into the report, and how it could come forward later.
So that'll be a move by Counselor D'Angelo, and I don't need a seconder now, I'll get it during the meeting. Okay, yeah, is right?
No, it's just like a motion.
Okay, can I get a seconder for that? Counselor DeRose, okay? And that will be referred to tonight's council meeting,
Excellent.
okay?
Okay, and
That's it.
carried, or,
Do we vote on that?
yeah, just like every
Okay.
committee, it's still a motion based.
All those in favor? Opposed? That is carried. Okay. There being no further business, this meeting is hereby adjourned at 6:13 PM. And just so everyone knows, there's pizza in room 1, okay? And we're back in